Welcome to the third module. This is where we talk about the financial issues and property settlements in your divorce. This is a pretty lengthy topic, so we've divided this module into 6 separate sections for each of the financial considerations. The sections will be divided as follows. First, spousal support issues. Next, household goods and furnishings and personal property division. Third is dividing up the real estate. Fourth, dividing up your retirement interests. Fifth is dividing the marital debts. And 6 are the tax considerations. What we won't be covering today are any business interests, since I believe that you really need to talk to an attorney before you're dividing up a business. Before we move to the sections, let's talk about how the courts will be reviewing your financial settlement in your divorce. The most important thing you need to understand is that your divorce settlement needs to be fair and equitable. That's the language in the statute. Now, this differs from other states that are called community property states like California, and that division is supposed to be 50-50. Now, that doesn't mean that your divorce can't have the property division be 50-50. In fact, what's the easiest way to divide a dollar? 50-50. So anyway, you just need to understand that it needs to be fair and equitable. So let me give you an example. Let's say one spouse drives a Tesla and the other spouse drives a 10-year-old Ford pickup. Well, would it be fair and equitable for the parties to go and say, well, you get the Tesla and you get the pickup, especially if it depends on what the values are of those vehicles. So I just want to give you that idea that, maybe it is fair and equitable if the Tesla, more money is owed on it than it's worth, and the 10-year-old Ford is in really good condition and it's got a higher fair market value on it because it's paid for. So those are the things you need to think about in determining whether you have fair and equitable settlement. The next important factor that you need to understand is that each of you has an affirmative duty in the law to report your finances to the other party. This means you can't wait for the other person to ask you what you have. You actually need to be handing over all of your financial data. And let me just give you an idea about that. I had a case where the fellow didn't tell me that there was a snowmobile that he had gotten from his brother, but hadn't changed the title on it. Well, it was sitting in the party's storage unit, and sometime between the time the divorce was finalized and his discovering it, wife had gone and taken off with it. Well, neither party had reported it in the divorce, and so as far as the courts were concerned, that snowmobile didn't exist, so wife got it by default. So it is really important to remember. You really need to lay all your financial cards on the table, and then it goes into the property division. So then the next question is marital assets versus non-marital assets. And that can be more important in a shorter term marriage than in a longer term marriage where really everything has gotten jumbled together. So the legal principle involved is if you are asserting a non-marital claim, then it is your burden, meaning it's your responsibility to prove to the court that it is non-marital. Now, think about Aunt Betty's cookie jar, and you're claiming a non-marital interest in that. Well, it might be that you have the card that came with it that said, here's Aunt Betty's cookie jar, or you have a picture of it in Aunt Betty's house. So that's just, one way. And hopefully you don't even need to go there, and that your spouse is going to say, yep, that's your Aunt Betty's cookie jar, and there won't be any issue. But just understand that in terms of non-marital issues, there's a statutory presumption that everything is marital unless you can show your non-marital interest. Although there's a few things that the courts presume are non-marital, and that's basically gifts from third parties, not gifts to each other, those are marital, and inheritances that you receive, again, from third parties. Oh, and there's a third one too, which is if you got pain and suffering settlement on a personal injury claim, and those are presumed to be non-marital also. Although what would be marital is any lost wages. So if that is important, you need to talk to your personal injury attorney that represented you on that to find out exactly how that was structured. So the next question you need to answer, and this is all a prelude to our sections, is determining what is the net value of an asset. And so I just want to give you an example. Is most of you have homes, and so you look at what is the fair market value of the home. And in the example, let's just say the home is worth $300,000. And then you have a mortgage on the home of $100,000. That means that the net equity in the home is $200,000, and that's what you're going to divide between the two of you. You don't take the full fair market value, because if you think about it, and I had this in a case going on right now, is the husband thinks that he should get, the home value of $400,000, his half of it, instead of the fact that there's a $200,000 mortgage on the home. And what I'm having to explain to him is that, well, essentially $100,000 of the value of the mortgage is his too. So since she's going to be keeping the house, he basically gets $100,000 of the net equity of the home. So the next thing you need to consider in your settlement is what is going to be the disposition. And basically, you're looking at 3 dispositions. One of you keeps it, spouse A, spouse B, or 3, sell it. And you want to get it sold before the divorce ends if possible, because obviously that makes it easier in terms of the language. And finally, what I think you should do is you should prepare an asset balance sheet. And it does look like there are some asset balance sheet on the court website, but also we're going to be providing one for you as a part of these materials. And then finally, the final consideration that you need to think about in working on your settlement is what is the valuation date that you're going to use? Because you can't, everything is changing in value every day, especially if you're talking about financial matters. The market's going up and down all the time. And so what you do is you pick a snapshot. And if you don't pick it, the court's going to pick it for you. But since you're doing it yourself and hopefully reaching these agreements on your own, what you want to do is pick a date that makes the most sense. So a lot of folks will pick the date that they separate. It needs to be if you guys sit down and decide that on December 31st, that we're going to separate the bank accounts. That would be a good valuation date. But the court, if you can't decide, like I say, the court will pick it. In some counties, they pick the date of the ICMC, which we talk about in another module. And some courts then, the statute actually says they're going to pick the date of pretrial. And so I just want you to know that the two of you can decide what your valuation date is. And if there's an agreement, just use that date. And use a date that makes sense, like say the end of a quarter if you have a lot of financial issues, or the end of the year. So that's all I need to cover in this section. Let's move on to each section.